Today, I'm showing you the exact clauses that determine who walks away victorious in franchise disputes right here in Florida. After watching this, you'll be able to identify the red flags in any franchise agreement before you sign. I'm Santiago Cueto, board-certified international business law expert and best-selling author. I've seen careers destroyed by contract clauses that business owners never bothered to read. Recently, there was a franchisee in Miami. He lost everything. The franchisor terminated his agreement after 15 years of successful operation. He thought he had a solid case. His lawyer thought so too. But one clause, buried deep in his franchise agreement, destroyed any chance he had in court. Now, most franchise owners never read their entire agreement. They sign on page 47 without even understanding what they just agreed to. Then a dispute happens. Maybe the franchisor wants to terminate. Maybe the franchisee wants out, or maybe there's just a disagreement over territory rights or royalty calculations. Suddenly, those unread pages become the most important document in that business owner's life. Now, I've represented both franchisor and franchisees in Florida courts, and the outcomes almost always come down to specific contractual provisions. Not fairness, not common sense, just what the contract says. That's what governs. Florida courts enforce franchise agreements aggressively. They rarely rewrite bad deals or rescue franchisees from agreements that they voluntarily signed. You can't just say, well, I didn't mean that. The language of the contract is going to dictate. Let me show you which clauses actually matter when disputes go to litigation. The termination clause is where most disputes begin. This provision tells you exactly when and how the franchisor can end your relationship. I just recently worked on a case where the termination clause allowed the franchisor to cancel the agreement for any material breach with just 30 days to cure. It sounds reasonable until you realize the franchisor gets to decide what counts as material. The franchisee, in that case, received a cure notice for using an unauthorized vendor, not for poor performance, not for customer complaints, just for buying supplies from someone other than what's on the approved list. He fixed it within a week. It didn't matter. The franchisor still terminated. Why? Well, because the clause also said that 3 cure notices in any 12-month period allowed immediate termination without another opportunity to cure. He had received 2 other minor notices earlier that year. The contract gave the franchisor absolute discretion, and the court enforced it exactly as how it was written. And that was a proper approach. Now, another clause is the choice of law and venue. The choice of law and venue clause determines where your case gets heard. This matters more than most people realize. Your franchise agreement probably says all disputes must be resolved in the franchisor's home state under that state's laws. Now, if you're a Florida franchisee and your franchisor is based in Minnesota, you might be flying to Minneapolis for court hearings. That's something you probably don't want. These clauses are almost always enforceable in Florida. Again, the court is interpreting the contract as it was written. I've seen franchisees spend more on travel and out-of-state legal fees than their actual claim is worth. The franchisor knows this. It's a strategic advantage built right into the contract. Now, if you're getting value from this breakdown of franchise law, hit that like button right now and subscribe to this channel so you don't miss my next video on business litigation strategies that actually work in Florida courts. Now let's talk about the clause that franchisees fear most. This is the non-compete and non-solicitation provision, and it can destroy your future. These clauses typically prevent you from operating a similar business for a set period within a defined geographic area after your franchise ends. In Florida, courts will absolutely enforce reasonable non-competes. The key word is reasonable. I represented a franchisee who sold smoothie products. His non-compete barred him from any health and wellness retail business within 50 miles for 3 years. He thought he could open a gym. Wrong. The franchisor sued. The court found the restriction was reasonable because the definition of health and wellness was clearly stated in the agreement, and a gym fell into this. He signed away 3 years of earning potential in his industry. The clause also prohibited him from soliciting any customers he served during the franchise relationship. That meant his entire customer base was completely off limits, well, at least for 3 years. Now, even if customers who wanted to follow him to his new business, they couldn't do so without exposing him to breach of contract claims. Now, here's another one, the arbitration clause. The arbitration clause might be the most powerful provision in your entire agreement. Many franchise agreements require all disputes go to binding arbitration instead of court. You give up most discovery rights. You often pay half the arbitrator's fees, which can run into 6 figures easily for complex cases. Arbitration heavily favors franchisors in most situations. And the proceedings are private. There's no public record. Precedent doesn't matter as much. And here's the critical part. Arbitration decisions are almost always impossible to appeal. If you lose permanently. There's no appellate court, there's no Supreme Court. You just lose, and it ends right there. I recently reviewed an agreement where the arbitration clause also included a class action waiver. This meant that the franchisee couldn't join with other franchisees to bring a collective claim, even if they all suffered the same harm. Each person had to arbitrate individually. The cost of individual arbitration often exceeds the amount in dispute. The franchisor, they know their math. And here's another one, the indemnification clause. The indemnification clause requires you to defend and pay for any claims related to your franchise operations. Let's say a customer slips and falls in your location. You indemnify the franchisor for any lawsuit that follows. An employee sues for discrimination, you indemnify the franchisor. Someone claims your marketing violated their trademark, you indemnify the franchisor. These provisions are broad, and that's done on purpose. They often require you to hire lawyers to defend the franchisor, even when you disagree with how they want to handle the claim. You pay their legal bills on top of your own. In one case I handled, the indemnification clause also covered the franchisor's reputational damages. The franchisee had to compensate the franchisor for alleged harm to the brand, even though no court ever found actual damages occurred. How crazy is that? Now, here's what you need to understand. These clauses aren't negotiable for most franchisees. Franchisors use standard agreements. They rarely make changes. Your leverage comes from knowing what you're signing before you sign it. Read every page. Have an experienced franchise attorney review it. Understand your risks up front. Now, if you're already in a dispute, your existing contract controls everything. The clauses I just explained will determine your outcome more than the facts of your case. Good lawyers know how to find small advantages within these provisions. Bad lawyers ignore them until it's too late. If this video helped you understand franchise agreements better, give it a like and subscribe to my channel for more practical legal insights. I break down complex business law so you can protect yourself. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.